Attorney and Branca, and today's show, the Law of Self-Defense News and Q&A show. See if I can get anybody in the comments to admit that they've joined the show for the second attempt of the day. We should also be streaming on the Law of Self-Defense membership site. It looks like we are, and it looks like I might have messed up the chat settings on the membership site. Sorry about that, folks. We're working with imperfect information today. Hey, Ken. Hey, John from Fort Lauderdale. Thanks, folks. If you're in Facebook and watching this live, if you could please leave a comment with your city and state, that always just confirms that I've got a good connection and gives me some geographic context for our discussion. This is the hour-late Law of Self-Defense News and Q&A show for October 15th, 2020. We tried it at 4 o'clock. You might have noticed also that I'm not wearing my normal lawyer attire, and the background will reveal that I'm not in the normal Law of Self-Defense HQ. We are on the road. We are using an imperfect version of our studio setup, questionable internet and all that, but I thought I'd make our best effort to put on today's show regardless. We tried at the normal time, 4 p.m. Eastern time. By the way, folks, if you don't know, you can catch this show live every week. The Law of Self-Defense News and Q&A show at 4 p.m. Eastern time here on Facebook, on YouTube, also for Law of Self-Defense members on their membership dashboard. This is the only content we produce each week that's open access, meaning you don't have to be a Law of Self-Defense member. So if you'd like to get a good idea of what we do and how we do it, this weekly news and Q&A show would be the one to go to. Because we do it every week, Thursday, 4 p.m. Eastern time, I encourage you to bookmark it in your calendar so you don't ever have to miss an episode. Okay, folks, so I think we have enough to get started on some substance. As always, of course, however, I do have to give a shout out to today's sponsor, and that is Ccw Safe. Ccw Safe, as many of you will know, is a provider of legal service memberships, what many people mistakenly call self-defense insurance. In effect, Ccw Safe promises to pay its members legal expenses if they're involved in a use of force event, and those expenses start big and get bigger fast, folks. Say, for example, you're involved in an incident where you feel threatened, you present your gun, don't shoot anybody, don't hurt anybody. Now you can easily find yourself charged with aggravated assault, a felony. The retainer for your lead counsel will probably be in the range of $30,000 to $50,000, and that's not for trial, folks. That's for pretrial. That's what you pay to try to get the charges dismissed, so you don't have to go to trial. At trial, they go up from there. And if it's a killing case, if you've actually shot and killed someone in self-defense, but find yourself now charged with murder or manslaughter, it's quite easy to burn through $100,000, $150,000, $200,000 pre-trial. Just multiply that for the trial itself. So it can be helpful to have a financial partner who can provide the kind of resources you need and want to fight that legal battle the way you want it fought, which is as if your life depends on it, because for all practical purposes, your life does depend on it. So CCW Safe can be very helpful in providing those financial resources, as well as considerable legal expertise in their own right. Now, there are several other companies out there in the marketplace who purport to offer similar financial backing for use of force legal defense cases. I've looked at all of them. As you might imagine, I found that CCW Safe was the best fit for me. I'm personally a member of CCW Safe. My wife, Emily, is personally a member of CCW Safe. Whether they're the best fit for you is something only you can decide, but I do encourage you to take a look at what they have to offer at lawofselfdefense.com/CCW Safe. And if you do decide to become a member with CCW Safe, you can save 10% off your membership with them with the discount code LOSD10. That's LOSD for Law of Self-Defense and the number 10. We also, of course, have our own Law of Self-Defense membership, which is how you get access to all our weekly content. That's not the weekly news and Q&A show. Most of our content is members-only content. To give you a sense of the kind of content we've delivered to our members in the last week, we had and all this content is in video form, much as you're watching it now, audio form through the Law of Self-Defense members-only podcast, and as text blog posts on our members-only blog, where we have the additional benefit of being able to provide downloadable contents, affidavits, motions in court, links to court decisions, and so forth. So our members get that multimodal delivery of all this content. But just about a week ago, we did a blog post, video podcast on the McCloskey case, and noted a number of key areas that most people are getting wrong in understanding the charges that are brought against the McCloskeys, why they're being brought, what the political and legal implications are, and so forth. So we went into depth on that. We also did a blog post on the shooting right in my home neighborhood of Denver by Matt Doloff of Lee Kentler. There we see the sad aftermath there. And we point out a couple of legal reasoning errors, traps that people are falling into, particularly the notion that pepper spray is always merely non-deadly force. That's not the case. That's a mistake. And that it matters who actually used force first. That can matter in a use of force legal analysis, but it's not necessarily at all decisive in determining whether or not that use of force was lawful or not. So we explored all those issues in detail there. And then, of course, we came back to the case again, the same Doloff v. Kentler case, a day or so later when we did a blog post on looking at provocation with intent and how, if provocation with intent occurred here, and there's some evidence that would allow that inference, although we don't yet know for sure, of course, that provocation with intent strips the provoker of any privilege to claim self-defense as justification for use of force entirely. So if that can be demonstrated by credible evidence, then somebody is in a great deal of trouble. And I also have a whole bunch of still photos of this event, this shooting, one of which you see here on the screen. But the Denver Post has since published a whole series of stills. They appear to be all the still photos they have. They're sequentially numbered. They provided the metadata for those. And I'd like to step through the dozen or so that are most relevant in terms of the physical action of this confrontation between Doloff and Kentler. We'll do that in today's show before we get to the end. It still doesn't tell us everything. Still photos have real limitations in terms of providing us with anything like a complete picture. Nevertheless, they are evidence. They are informative. We can make some inferences from those still photos. So we'll step through them in today's show and discuss what lessons or inferences we can draw from those still photos and the ways in which the still photos still leave us with an incomplete understanding of what happened, despite how many of them we have and how timely they are and how clear they are in their own way. Okay, folks. So, by the way, if you are interested in being able to access all that membership content, Law Self-Defense membership is extremely inexpensive. It's only about 33 cents a day. Under normal circumstances, it's less than $10 a month for world-class legal insight, education, expertise provided to you many times a week. And, of course, the archives go back for many, many weeks, months of access, if not more. So we're talking dozens and dozens and dozens of hours of video, podcast, written text posts on all these high-profile use of force cases. Worst case, standard membership is under $10 a month. You can try out membership for just 99 cents for 2 weeks. If you decide it's not for you and you'd like to cancel, do that anytime, no questions asked, and we'll refund 200% of your money, which granted is only another 99 cents, but let's face it, we didn't ask you to put up very much to give it a try. The point is it's a negative risk opportunity, folks, to try out Law Self-Defense membership. And if you decide to stay a member, again, it's only about 33 cents a day. Hopefully, this kind of expertise is worth 33 cents a day to you. But again, that's a call only you can make. And of course, you're free to do exactly that. If you'd like to try out the Law of Self-Defense membership trial, you could do that at lawofselfdefense.com/trial. Just 99 cents, folks. All right, let's jump into the meat of today's show. So this is our weekly news and Q&A show. For those who don't know, I'm attorney Andrew Branca. I'm an attorney who does nothing but use of force law cases, has for almost 3 decades now. Next year will be 3 decades since I was admitted to the bar. Holy cow. But all we do is use of force cases. We don't have a generalized criminal defense practice. We don't do DWIs or shoplifting or anything like that. Only use of force. And we try to share that expertise with all of you, the general public, by translating the legalese of statutes, court decisions, jury instructions into plain English that's not just understandable, but actionable for you, so all of you can be as well prepared to win the legal fight as you are prepared, hopefully, to win the physical fight, should you be compelled to use force in defense of yourself, your family, others, or your property. So that's our mission. One of the ways we do that is by delivering an enormous amount of content to our Law of Self-Defense members, but we also do this one show every week, our Law of Self-Defense News and Q&A show, where we answer questions that have been sent in beforehand. We'll answer questions that are asked during the live show. So if you're on Facebook or on the Law of Self-Defense membership, unfortunately, it looks like I forgot to turn on chat for today's membership broadcast, the live broadcast. Sorry, folks. But it is, of course, the commenting is up on Facebook. So if you want to hop over to Facebook to ask questions live there, that's certainly no problem. If you are a Law of Self-Defense member, if you're a platinum level member, you have the option of using the platinum member only Q&A form on your membership dashboard. We always answer those, and we have a couple of those platinum level member questions that came in this week that we'll certainly address. Or alternatively, if you'd like to send questions in ahead of a show for our consideration, you can email those to show@lawofselfdefense.com. We can't promise to answer every question, but we certainly will review them and take them under advisement for a future show. We have a few of those questions that were sent in as well. But before we dive into the Q&A portion, I always like to cover some of the use of force stuff that's been in the news. So I'll talk on a few of those topics. One is the news that just came out in the last couple of days that Kyle Rittenhouse is not going to be charged in Illinois for any gun charges related to his possession of the AR rifle he used to defend himself that night in Wisconsin. There had been some suggestion, usually suggestion that's of the ill-informed propaganda type nature, that Kyle had possessed the rifle in Illinois under circumstances where it was unlawful for him to do so. Illinois, as you know, has some very rigorous gun laws. The punishments are severe. Now, Kyle's side of the narrative was consistently saying that he had not transported the gun over state lines. And in fact, he was provided with the gun in Wisconsin, that he never possessed it in Illinois, in which case, of course, there couldn't possibly be any Illinois gun charges. And the Illinois authorities investigated the matter, concluded that, in fact, Kyle had been given the gun in Wisconsin. He had not possessed it in Illinois. There's no evidence of that, either the gun or any illegal magazines or anything else that could have been the basis for an Illinois-level gun charge. So there will be no Illinois gun charge against Kyle. Now, one of the reasons many people, the anti-Kyle narrative people, were pushing this whole gun propaganda that Kyle had possessed the gun illegally was because of their successive argument, which was that, well, if Kyle had the gun illegally, that's committing a crime. You can't claim self-defense if you're committing a crime. Therefore, Kyle can't claim self-defense for shooting the three men who attacked him that night. That line of reasoning was complete nonsense. There is no general prohibition in Illinois or Wisconsin on claiming self-defense just because you might have been committing some generalized kind of criminal offense. There are, of course, criminal offenses that would make you the aggressor in a fight, and therefore you would lose self-defense because you were the aggressor. But there's no requirement that you be 100% free of criminal conduct generally in order to qualify for the privilege of self-defense. So, for example, you could be a street corner drug dealer engaged in the unlawful dealing of drugs. You still have the right to defend yourself against someone attempting to commit an armed robbery of you, for example. Now, if that goes down and the authorities get involved, you may well get charged for the drug dealing, but it does nothing to take away or limit your privilege of self-defense justification for using force in defense against an unlawful attack upon you. So even if Kyle had possessed the gun illegally, he might have been on the hook for some kind of gun charge, but it would have had no effect at all on his privilege of self-defense with respect to defending himself against the three men who attacked him that night. So I've had to explain this ad nauseum. The fact that the gun charges are now off the table, at least in Illinois, hopefully means I won't have to explain that particular issue again. I suppose there's also an argument that there may be some gun charge in Wisconsin. At worst, it would be a misdemeanor. I don't really expect that to go anywhere, probably. But in any case, similarly, that offense, if there is any, under Wisconsin law, would also do nothing to limit or constrain Kyle's right of claiming self-defense under Wisconsin law. So it just doesn't matter, folks. There was another story sent my way, and I'll try to link it in the text version of today's post if I have the opportunity. It's not a very important story, but it was just involved a shootout, apparently in a shopping mall between two competing groups of young men over an argument over rap lyrics. I guess the opposing groups were claiming credit for rap lyrics or had some other dispute. In any case, it ended up in a gunfight in the mall. An innocent bystander was killed. Naturally, the prosecutors want to hold somebody accountable. But both of these opposing groups in the confrontation are saying, well, I was just shooting in self-defense. And the nature of the factual evidence is such that they each have a credible argument that they were acting in self-defense. In other words, each side may have had a reasonable perception, even if it was a mistaken perception, a reasonable perception that they were facing an imminent, unlawful threat of death or serious bodily injury that would justify their use of deadly defensive force. And they both could have believed that. Again, you don't have to be right in self-defense. You have to be reasonable in self-defense. So each side may have a credible claim to self-defense that they would present to a jury that a jury might buy, which presents a conundrum for the prosecutor because the prosecutor wants to hold somebody criminally responsible for the death of this innocent bystander, a young woman, if I recall correctly, who was doing nothing at all wrong. Again, just an innocent bystander. So when a prosecutor is in this position, one of the things they'll try to do is they can see that if they try to attack Group A's use of force, Group A is going to raise a self-defense defense, justification. If they try to attack Group B's use of force, and apparently there's some ambiguity about whose bullet actually caused the death of the bystander, but if they try to attack Group B's use of force as being responsible unlawfully for the killing of the bystander, Group B is also going to raise a legal defense of self-defense. So, and it's possible both those claims of self-defense could win, and then you have nothing. So when a prosecutor faces that dilemma, well, they know there's other avenues they can use to attack these claims of self-defense. And one of them is to argue mutual combat, that in fact, both sides were not each innocent defenders in this gunfight. Even if mistaken, they were not innocent defenders. They each had implicitly agreed to settle their differences with physical combat, to wit, a gunfight. And when two groups or two people mutually agree to settle their differences through physical combat, they both become mutual aggressors. They both lose the element of innocence. And if you've lost the element of innocence, you've lost self-defense. So what the prosecutor's trying to do in that case is say, kind of invert the defenses. The defenses are, hey, each of us is able to claim self-defense. That's what we're going to argue at trial. We each had a reasonable perception of an unlawful, imminent threat of deadly force. Therefore, we were each justified in firing shots to neutralize that reasonably perceived threat. Prosecutor is going to say, well, you may have each had a similar state of mind. But if you did, it was an unlawful state of mind. It was a state of mind of malice. It was a state of mind of mutual combat. And rather than raising the legal defense for each of you, it actually strips each of you of that legal defense of self-defense. So the facts of the case aren't, and the law of the case isn't all that interesting or exciting, but it's just an example of how a prosecutor, when they conduct their own legal analysis, looking for the strengths and weaknesses of the defenses they expect they'll have to face at trial, this is the kind of step-by-step analysis they would do to come up with what they think are the attacks on the defense that are most likely to be effective. Remember, the prosecution is going to have to disprove self-defense beyond a reasonable doubt in this scenario for both parties or whoever they plan to hold accountable. And if they can convince the jury that it was mutual combat, the prospects of self-defense being bought by the jury as a legal defense diminishes considerably. There was some more news in the Rittenhouse case that came up just in the last day or two, and that was that there was, from the very beginning, there was evidence on video and from a reporter who was at the scene within feet of the parking lot attack on Rittenhouse, who testified, or I should say gave statements about this, that he observed, and it was caught on camera, what appeared to be gunshots, muzzle flashes, In the moments before Rittenhouse engaged his first attacker, the man chasing him across the parking lot, the apparently convicted pedophile chasing him across the parking lot. And these gunshots, not fired by Kyle, fired by somebody else. But the nature of the gunshots and the direction of the gunshots may well have created in Kyle's mind a reasonable perception of a deadly force threat, an imminent deadly force threat, an unlawful imminent deadly force threat against which he would be privileged to defend himself, a deadly force, justifying his shooting of the man chasing him across the parking lot. And of course, he did ultimately turn and shoot that man and kill him. We think there's still ambiguity about whether or not the bullet that killed the parking lot pursuer actually came from Kyle's gun. I'm not sure if that's been settled yet. But for our purposes, let's assume it was Kyle. Certainly Kyle was shooting at him. There's no question about it. So for our purposes, let's assume that it was one of Kyle's rounds that actually caused the death. For that death to be lawful self-defense, Kyle would have had a reasonable perception of an imminent deadly force threat, and those shots fired immediately prior would have been circumstances that could well lead to a reasonable perception of an imminent deadly force threat. And now the person who actually fired those shots has been charged by police, which makes the factual claim all that more credible, and therefore very much buttresses Kyle's claim of having that reasonable perception of an imminent deadly force threat at the time he fired the first shots that he fired at the parking lot pursuer. And it was, of course, everything else kind of naturally flows from that. If that was a lawful use of force, then when Kyle was pursued after that, well, he'd only used force lawfully. The attacks later in the street against him, where he fired more shots, killed a second person, seriously wounded a third person, also increasingly look like lawful self-defenses. Of course, most of us in the law of self-defense community perceived from the very beginning. But all of this is emerging evidence that's favorable to Kyle, that strengthens his narrative of innocence. And by the way, folks, this is how these cakes are typically baked. And what I mean by that is, in my experience, where you have a case that's at all resembles lawful self-defense, it's very common to get a burst of facts, quote unquote facts, claimed facts, a narrative at the very beginning. That's often large parts of it, especially the narrative of guilt, the narrative of malice, the narrative of negligence, is often based on lies, falsehoods. Some are just misunderstandings. Some are malicious falsehoods created for monetary or political or propaganda advantage. And so often the worst view we have of these cases is the view that emerges over the first 4, 6, 8, 10, 12, 24 hours. And that's the worst case narrative. And then as more evidence emerges over successive days and weeks and sometimes months, almost invariably that newly emerging evidence is favorable to the narrative of innocence, is favorable to self-defense. We certainly saw that in the George Zimmerman case. We saw that in the Officer Darren Wilson shooting of Michael Brown case. We see that in most of these, really all these cases, virtually all of them. The worst cases, the lies were told up front. You'll remember Breonna Taylor, we were told, was shot sleeping in her bed. Well, of course, we now know that's not at all true. In fact, she was standing next to the person who was shooting at police, which is how she got struck by the police return fire. And I expect that pattern to hold true in the Kyle Rittenhouse case. I think every bit of new evidence, facts that gets released over time, that gets brought to our attention, that gets buttressed by other supporting consistent evidence, whether circumstantial or direct evidence, is going to be, I would expect, evidence that's increasingly favorable to Kyle Rittenhouse. So that would be my expectation. I could be wrong. Sometimes there are exceptions to that kind of rule of thumb, but that is certainly the norm in my experience. Something else that came up. So I saw somebody on Facebook, and I'm not going to post up an image of their Facebook comments because it's not my purpose here to embarrass them personally. But someone had made a comment that, you know, if the shooter in Denver, Matt Duluff, who shot Lee Kentler, if the shooter had, instead of using a gun, had used a stick or a club to beat Keltner to death, he wouldn't be facing charges today. The idea being that there's some meaningful distinction between shooting someone to death, and of course, Doloff shot Keltner in the head with a single shot, killed him instantly. Keltner was almost certainly dead before he hit the ground. That there's some substantial difference, morally or legally or any other way, between shooting someone to death and beating someone to death with a club. Folks, there's not. If you're using deadly force, it's deadly force, period. The law doesn't really distinguish between, the law doesn't really recognize different degrees of deadly force. If you're shooting someone in the head, shooting someone to death, or beating them to death, or choking them to death, or drowning them to death, or burning them to death, you see the common pattern, right? It's death. If you're using force readily capable of causing death or serious bodily injury, you're using deadly force, period. They're all substantively the same. There's no real distinction between them. That's not true of non-deadly force. If we're talking in the context of non-deadly force, there are degrees, a continuum of degrees of non-deadly force. So a finger poked to the chest is a lesser degree of non-deadly force than a punch to the face, or than OC spray to the face, for example. So within the non-deadly force bucket, you have to be careful to maintain proportionality within that bucket. Once you find yourself in the deadly force bucket, however, effectively all deadly force is equal to all other deadly force. So no, you're not facing less legal liability if you beat someone to death with a club relative to whether you shoot them with a gun. Now, where there can be differences in the means of deadly force is not so much in the self-defense claim or the criminal responsibility area of the law, but rather in the sentencing area of the law, because a lot of states have sentencing enhancements for the use of firearms against someone unlawfully. So you have the sentence for whatever the underlying crime was. Let's call it manslaughter. And then there may be a sentencing enhancement if you committed the manslaughter with a gun or with a semi-automatic gun or whatever the state has for a sentencing enhancement. And sometimes the sentencing enhancement can carry more time than the underlying criminal offense. So it can matter a lot whether or not you use the gun in the punishment stage of the criminal proceedings, the sentencing stage. But in the guilt stage, it doesn't really matter how you killed them, folks. If you killed them, you better be able to justify the use of deadly defensive force, or you have 100% criminal liability for an unlawful killing, and that's not a good place to be. Anthony C., one of our platinum members, had used our Law Self-Defense Platinum Member Q&A form to send in a question about a blog post that had been done by Ccw Safe. As I mentioned at the beginning, Ccw Safe is a partner, a sponsor of Law Self-Defense. I like the organization. I'm personally a member, especially their National Trial Counsel, Don West, who was one of George Zimmerman's attorneys at his trial, along with Mark O'Mara. I think the world of Don West. I think it's a fantastic criminal defense attorney. I think anybody who has Don West on their side in the criminal defense proceeding is very many steps above where they would otherwise be. And CCW Safe also does a regular series of blog posts. And they had done one very recently, just this past week, on the subject of justifying your use of deadly defensive force based on the hypothetical notion that you were defending against a forcible felony. So the core privilege to use deadly defensive force is based on the notion that you were defending yourself against an imminent unlawful threat of deadly force against you. So you're being threatened with deadly force, you can use deadly force in self-defense. There are a number of states that say that in their self-defense law, but they also add so deadly defensive force is lawful if used to defend yourself against a deadly force attack or to defend yourself against a forcible felony. And then generally they have an enumerated list of the forcible felonies they have in mind. Sometimes it's a long list, sometimes it's a short list. It typically includes things like kidnapping, rape, aggravated assault, aggravated battery, things along those lines. And the reason these forcible felonies are included as part of a foundational justification for the use of deadly defensive force is generally because forcible felonies, it's in their nature, key characteristic that they involve, inherent, baked into the cake of a forcible felony, is an imminent threat of death or serious bodily injury. Someone's raping you or kidnapping you or committing an Aggravated assault or battery, well, that's an assault or battery that threatens death or serious bodily injury. So it's all kind of baked into the cake. What's not included as a justification for the use of deadly defensive force is a non-forcible felony, because there's lots of felonies that are not forcible. You write a bad check over a certain dollar amount, it's a felony. But no one would say that writing a bad check over a certain dollar amount entitles another person to use deadly defensive force against you. Now, we might want to live in a society where that was permitted, but in fact, that's not permitted because writing a bad check is not a forcible felony. So the blog post was basically discussing all these notions and concepts. And of course, it raises questions really about the idea that, well, what if you were theoretically facing a threat of a forcible felony, but did not believe that, in fact, you were facing an imminent threat of death or serious bodily injury? What should you do there? What would the law allow you to do there? Well, in theory, it's possible that could happen. It's possible that someone could be committing an armed robbery of you, a robbery enforced by threat of death or serious bodily injury, but you don't actually believe that you're facing an imminent threat of death or serious bodily injury. Now, they're committing the crime. They're committing the felony that qualifies as a forcible felony. And on that basis, the law says you'd be justified in using deadly defensive force. But should you use that deadly defensive force if you genuinely don't believe that you're actually facing an imminent threat of death or serious bodily injury? Well, in some of these cases, the law would allow you to do that. Use that deadly defensive force. I would strongly suggest that that's not the decision you want to make. I would strongly suggest that if you're using deadly defensive force against another human being, that it is a last resort position, that you really have no alternative. Because as we often say here, the moment you get involved in a confrontation, and especially a deadly force confrontation, let's assume you actually kill the person. Well, now you've just incurred some risks you weren't incurring a moment before. Among them are, well, maybe you don't win the fight, right? Maybe they do kill you. So that's not a good place to be. Or maybe you win the fight, you end up killing them. And now you're being compelled by a prosecutor to make your deadly force justification claim in front of a jury, with the prospect that if you're unsuccessful, and folks, it's never 100% lock. There's always at least a 10% chance that a jury is going to find you guilty. That's just the noise in the system. So if a prosecutor compels you to make that justification in front of a jury, and there's a 10% chance of getting convicted, and conviction carries life in prison without possibility of early release, and you weren't, in fact, facing an imminent threat of death or serious bodily injury, is that outcome worth it? Is the risk of that outcome worth it? Even if the law would say, well, you've got a good legal defense there, 90% chance of making it, selling that to a jury, but 10% chance of going to prison for the rest of your life and having killed someone who arguably didn't have to be killed. That's not a position I would be in, and I would encourage all my students and clients to not place themselves in that position. In terms of Anthony's question about the CCW Safe blog post, I did read the blog post. It's quite lengthy. It's several hundred words. I would be happy to dive in detail on a specific question about a specific facet of the blog post, but I can't dissect several hundred words of blog post on the show. So really, you'd need to tell me if there was some particular statement or claim or a suggestion in the blog post you found disturbing. If you could point it out to me, I'd be happy to address it. I read it. I didn't happen to notice anything that was very disturbing. I think most of the CCW Safe stuff they do in the blog post is really good, very solid. I believe the author of this particular post was Steve Moses, and Steve does great work from what I've seen consistently. So I would be surprised if he said something zany. But if you wanted to, make your question more specific, send it in again in that same Platinum member Q&A form, and we'll come back to it again next week. We got another question from another Platinum member, David R. in Georgia. And he asked about an oral argument being made in front of the Georgia Supreme Court. And interestingly enough, of course, in this era of COVID, a lot of these oral arguments are being made over Zoom or some equivalent webinar type platform. And this one was. So it's all videotaped. So you can see the attorney making the oral argument, and you can see all the justices in the Georgia Supreme Court in their own little windows on the computer screen. They're asking questions of the attorney and so forth. And this case was about a shooting that occurred in a rather tumultuous setting. So there'd been some kind of car show involving lots of teenagers from a high school, so young men and young women, a formula for disaster right there. Apparently there may have been gang members present, Bloods, Crips, guns were shown, and fists were thrown and shots were fired. And now we have a defendant who's been convicted of aggravated, I forget if it was aggravated assault or aggravated battery, at trial. He's appealing his trial down to the Georgia Supreme Court. And essentially what the lawyer, the appellant lawyer, is arguing in front of the Georgia Supreme Court in oral argument is, let me take a step back. So at trial, the defendant who'd fired the shot was criminally charged as a result. He wanted the jury given a self-defense jury instruction, and they were kind of, except that the trial judge conditioned or appeared to condition. It appears ambiguous about what the instruction actually said, but it appears the trial judge may have conditioned self-defense on mutual combat. In other words, they told the jury, hey, first determine whether or not mutual combat occurred here, which it could have. It was a large group setting, perhaps mutual combat. And if you decide it was mutual combat, or if you decide it wasn't mutual combat, then you can look at self-defense. And the appellant's argument is, well, that jury instruction was incorrect. They should have considered jury instruction on its own merits, independent of mutual combat. Defendant didn't get a correct jury instruction. That's almost invariably reversible error, entitling the defendant to a new trial. And that's true. Every defendant is entitled to correct jury instruction. So if there's an error in the jury instruction that's at all meaningful, that could at all have resulted in a different verdict, a different outcome at trial, had the correct jury instruction been given, then the defendant ought to be entitled to a new trial with the correct jury instruction. And I say that regardless of what I think are the merits of the underlying case. It doesn't matter what the merits of your case are if you get a bad jury instruction. Everybody loses. Every defendant's going to lose if they have bad jury instructions, and that's not due process in any way that I understand it. Anyway, David R. had linked me to the oral argument, and he asked, let's see if I can phrase it here. Will this case alter the legal landscape of self-defense, use of deadly force in response to disparity of force situations? So one of the arguments of the defense was, hey, I was an out-of-towner. I was a guest there or a stranger there. And one of the reasons I resorted to deadly force was I had been punched. I knew, and there's evidence that there were gangs present. There's evidence that other people had guns present. And there was a huge disparity of numbers, and I reasonably feared a threat of death or serious bodily injury because of that disparity of numbers and these other circumstances. And therefore, I should have gotten a clean self-defense jury instruction. I didn't. That's reversible error. So on oral argument, the justices who don't appear to be buying into this narrative are saying, but could he have had a reasonable fear of a deadly force attack? I mean, he got punched, but you don't shoot someone because they punched you. Generally, a punch is considered non-deadly force. You can't respond with deadly defensive force to a non-deadly force attack. And in theory, these other circumstances, that they were outnumbered, that other people may have had guns, that gangs might have been present, in theory, those other factors could collectively give rise to a reasonable perception of a deadly force threat. But that doesn't mean they did here. For example, there's questions about whether the defendant did not testify at trial, so we don't know what he actually knew, but that leaves it ambiguous. For example, it seems other people in the crowd had guns, but it's unclear whether the defendant knew at the time that they had guns. It appears there were gang members present, but it's unclear that the defendant knew that there were gang members present. So these other circumstances existed, but if they weren't known to the defendant at the time, then they couldn't have influenced the defendant's decision-making, and then they don't exist for legal purposes in evaluating whether or not the defendant's claimed perception of a deadly force threat was a reasonable perception. So I didn't have a chance to look at the entire oral argument before this show started. Sorry about that, Dave. But Dave asks, in the context of all that, will this case alter the legal landscape of self-defense use of deadly force in response to disparity of force situations, such as in riots or multiple assailant home invasion situations? And if so, how? Well, we can't really answer that question just from oral arguments, because oral arguments are not a final adjudication. They're not a reasoned decision of the court. It's just a conversation, basically, that precedes a reasoned decision by a court. And you often can't tell much from the oral arguments. The real arguments, to my mind, frankly, are in the briefs, are in the written documents, the written arguments that are presented to the court. They're much more detailed. You know, when people speak, sometimes they stutter, they use the wrong words. There's a very tight time limit. There's only a 20-minute time limit in front of the Georgia Supreme Court for your oral argument. So you don't have a lot of time to make your points. You don't have a lot of time to correct any mistakes that you might have made and so forth. And you have plenty of opportunity to do that in the written briefs. So I think the briefs are actually a lot more compelling. But also in the oral argument, you'll have justices ask questions that might suggest they're leaning one way or the other, but they may just be asking for purposes of completeness or to explore hypotheticals, or the questions they ask may not, in fact, be how they actually think about the merits of the case. So we can't really draw any conclusions about how the judges might rule just from oral arguments. We'd like to, but it's very dangerous to do that. In any case, the only official, concrete, substantive law that results from the decision, from the case, is their actual decision, which needs to be written by one or more of the justices. So nothing in the oral arguments is itself law. So the oral argument itself won't change anything about Georgia law. Now, once they write their decision and they hand that down and we can read it, and hopefully, presumably, it will explain the rationale for whatever conclusion they come to, they may say things in that written decision that have an impact on Georgia law in the context of defense against disparity of numbers or mob events or violence, large group rioting, looting, arson type of events. But we just won't know until they hand the decision down. So when they do hand that decision down, I'll probably see it. If I don't see it, or if you want to just play it safe, send me a copy of the decision or link me to it, and I'll be happy to go over it in more detail, especially for our law self-defense members, especially for our platinum members just like you. Okay, I think that was all the prepared content I had. So let me go back here. Yeah, unfortunately, the chat is disabled on the membership dashboard. Again, my apologies for that. I'll slide through the Facebook. Casual Thursday. Yeah, folks, sorry. I'm traveling and I did not have my usual shirt and tie. And obviously, I'm not in my office. I'm in a guest room. But it looks like it worked out okay, technology-wise, once we restarted an hour late. So that's all good. At least it appears to be working from my end. All right. Well, I don't see too many questions here in Facebook. And let's see. I think we're streaming live to YouTube as well. Let me take a look there quickly. And while I'm doing that, I'll just remind all of you, we do these law self-defense news and Q&A shows every Thursday, 4 p.m. Eastern time is the normal time when we don't have technical difficulties. So I urge you, if you like this kind of content, to put it in your calendar so you don't have to miss a show. We air it live on the Law Self-Defense members dashboard. Of course, that's for our members only. Also on the Law Self-Defense Facebook page, which is facebook.com/Law Self-Defense. And on the Law of Self-Defense YouTube channel, which is youtube.com/Law of Self-Defense. This is the only content we produce every week that's open access. You don't need to be a member to access this content. Before we go, I forgot. I had all these still photos from the Denver shooting. So let me finish up these remarks and then we'll dive into those. Okay, so our weekly show. Be sure to join us next week. Now, I do want to step through a bunch of this stuff, these photos that were released by the Denver Post. And so I'm going to step through a sequence of these. These are the dozen photos that really capture, I think, the gist of the fight. And I've blown them up so they're larger than just a corner of the screen. So they'll obscure my face when I put them up, but I'll just talk over them. So here's the first of those. And it's a little weird because there's about, I'd say there's 4 or 6 photos before this, maybe more. I think it's more. But there's, and they're like a couple of frames per second or 1 frame per second, something like that rate. But there's a definite gap between the immediately preceding photo and this photo. So we kind of jump to this point in time. But when we get to this point in time, we see the victim here on the left. That's Lee Keltner, the guy who would be the shooter here on the right, Matt Doloff. And certainly Keltner here appears to be in an aggressive stance. Doloff as well. They're both leaning forward. They both have their feet nice and broad. Strong foundation for getting into a fight. Doloff is reaching out with his mostly with his left hand here, and his right hand is also up. Behind Doloff's arm, you can't see it; it's blocked by his arm. But Lee Keltner does have a pistol in a shoulder holster under his left arm, just inside that vest that's flapped open there. I don't believe we can see it in this picture, but it is there. And some people have suggested that perhaps Doloff was going for Lee Keltner's pistol under that shoulder holster. It doesn't particularly look like it here, but in any case, Doloff is reaching out with his arms, and Keltner is about to slap Doloff across the face. We can see his left arm out there. In his right hand, he's got a large can of bear spray, really a supersized can of OC spray. He doesn't seem to be imminently about to deploy it here in this image. It's kind of, he's been holding it in his hand the entire time. So it's not like he just presented it in this confrontation with Doloff. It was already present in his hand. It is there, but he doesn't seem to be imminently to use it. Now, if we look between Keltner's legs here, we can see kind of a sandbag at the base of a board that's holding the fence up. I just want to keep that in mind because it kind of locks in Lee Keltner's position here, because the men do move side to side, as we'll see in a moment, particular Keltner, the victim here. The photographer mostly maintains this precise position, so it's relatively easy to tell how the gentlemen move here. So if we go on to the very next frame, we get to this image here. So here we see Keltner's arm has made contact with Doloff's face. It's knocking his glasses, his hat, his mask aside. Keltner still doesn't seem to be raising the OC spray. Now, was this, and I would suggest this is a non-deadly use of force by Keltner. This might have been an active initial aggression. We don't know whether or not this slap was justified, because one of the shortcomings of still photographs is it doesn't show actual motion, right? We can't tell if someone an instant before was moving forwards or backwards, and it also doesn't provide audio, so we don't know if people were verbalizing threats. The nature of a physical act can change dramatically if it's accompanied by, say, verbal threats, for example, and we don't get that here at all. But in any case, here we have Keltner slapping Doloff. I would argue it's a non-deadly use of force at this point. A barehanded attack is typically a non-deadly use of force. We go to and we can still see that Keltner also still lined up more or less with that sandbag and the fence post immediately behind him. So we go to the next post, and we have the slap to the face finishing. Doloff's head is jerking in response, the hat, the glasses, the mask, and kind of Keltner is sweeping through. Again, we can still see the post behind Keltner, the sandbag, but he's clearly now, his body position is a little bit further back than it was a moment before. Maybe not enough to be a deliberate motion. Maybe it's just a consequence of the twisting of his body as he's throwing that slap to Doloff's face. But he's already begun to move back, and I think as we'll see, it appears that he continues to step backwards. So here he's clearly kind of leaning back. His arm is carried through, maybe still just a function of him twisting his body in the course of the slap. But he's certainly not advancing. He's not getting closer to Doloff at this point. Then we have the next frame. And again, he's even further back. Now the slap is fully complete. Here he has the bear spray raised up a little bit, but it doesn't appear to me like he's about to use the bear spray. It appears more how you would move your arm just to keep yourself balanced after slapping somebody. But of course, we don't know for certain because we can't mind read. The next frame, here Doloff's head is recovered from the slap. He's got his hands up. Keltner, the victim with the bear spray, is even further apart. seems clearly to be creating distance here. One thing we don't know is we don't know if Keltner knows at this point that Doloff has a gun, but he's going to discover it pretty quickly. Here, Doloff begins moving his hands towards the gun, which appears to be in an ambidextrous in the waistband holster. Keltner is still clearly moving back. Again, we can't hear what the men are saying, right? We don't know if Doloff is saying, "You MFer, I'm going to shoot you in the face right now," in which case that would obviously be an escalation to deadly force. Doloff here does not appear to be facing a deadly force threat from Keltner, who, if anything, is backing off. On the other hand, maybe Keltner is saying, "Oh yeah, you have a gun? I'm going to pepper spray you in the face, take your gun and kill you with it." Oh, well, that would be important information to know. Now, obviously, I'm just making that up, but the fact is either one of those exchanges could easily have happened and would change completely the dynamics, the legal analysis of this confrontation. We just don't know if any of that happened. Now, of course, we're not going to learn any of this from Keltner. Keltner's dead. But are we going to hear it from Doloff when Doloff ultimately testifies or his lawyer shares a narrative of the case? We get to the next frame, and Doloff's hand is out of sight now, but presumably reaching for or on the grip of his pistol. Keltner still appears to... It's hard to tell from the snapshot, but he's still further back from the post than he was when he threw the slap, that's for sure. I suggest, given the sequence of the images, that his weight is moving backwards. It's not moving forwards. We get to the next frame, and Doloff now has got both hands in a position to get a two-handed grip on the pistol as he presents it. Anyone who knows much about presenting a gun from this position, an observer would, certainly to my eye, Doloff now looks like a man going for a gun. There's not much question about it in my mind. Keltner still has that bear spray down at his side. And that's been consistent throughout. He's still further back from where he was when he had initially slapped Doloff. So it doesn't appear to me to be in a mode of aggression there. Certainly not deadly force aggression. We look at the next frame. The presentation of the pistol is in progress. Keltner now has both feet next to each other. He's not advancing or retreating, but he's clearly further away than he was at the beginning of the confrontation. We have Doloff getting the gun out of the holster now. Of course, Keltner's observing this. Maybe he perceives a deadly force threat as he sees the gun coming out. And then in the next frame, the next moment, we have simultaneously Keltner spraying Doloff with bear spray and Doloff shooting Keltner. And with that single shot, this would be, of course, the fatal shot right there. Keltner would be struck in the face and killed instantly. So what's happening here? Of course, the question is Doloff shooting Keltner in defense against the bear spray? Doesn't look like it to me, because the immediately preceding image, clearly for several frames, we saw Doloff already committed to presenting the gun. What's the deadly force threat here to Doloff? I don't see it. if there's some weird verbalization by Keltner, hey, I'm going to pepper spray you, take your gun and kill you with it, maybe. That could be a deadly force threat. OC, if used offensively, could be a deadly force threat, especially if there's additional evidence, circumstances from which to infer a deadly force threat. But absent that kind of weird verbalization, certainly from the conduct alone, I don't see a deadly force threat to Doloff at this point in time. And here, there's no pepper spray. The gun's already coming out at this point. So when we get to the very next frame where Keltner is spraying pepper, it appears to me he's spraying in response to the presentation of the gun, trying to impair Doloff's ability to unlawfully shoot him, which would be a lawful use of the pepper spray. You're clearly allowed to use pepper spray to prevent yourself from being unlawfully shot. So that's where I currently come down and what I think is the most likely narrative closest to truth in this case. I'm still open to my mind being changed as more evidence emerges, but right now that's how it looks to me. Okay, folks, I'll take one last look at Facebook. And it doesn't look like there's questions in there. And I don't know how to check YouTube, it turns out. So with that, we're right at the top of the hour as well, so I'll go ahead and sign off. Remember, please join us every Thursday, 4 p.m. Eastern Time live. If you like this kind of content and would like to try out Law of Self-Defense membership, you can do that for just 99 cents for a 2-week trial. If you decide you don't like it and cancel, we'll give you 200% of your money back, so it's a negative risk opportunity. If you decide to stay a member, folks, it's only about 33 cents a day, less than $10 a month to get hours and hours and hours of weekly and monthly Law of Self-Defense expertise, insight, education on these high-profile use of force cases. So you'll be the guy in your group or the gal in your group who knows what's actually going on from a use of force law perspective, as opposed to just relying on the nonsense and mistaken information and myths and memes and lies and propaganda that float out there among the internet. Okay, folks. So with that said, I will get ready to sign off. Just remember, as always, folks, if you carry a gun so that you're hard to kill, and that is why I carry a gun for sure, have my entire adult life, so I'm hard to kill, so my family is hard to kill, folks, then I urge you also to make sure that you know the law so that you're hard to convict as well. Okay, I'm attorney for Andrew Branca at Law of Self-Defense. Until next time, stay safe.